The main topics we will cover include what an interview is and when it is appropriate. We will also provide examiners with general guidelines on what to do when an interview request is made and how to handle the actual interview. We will briefly discuss when it may be proper to allow or not allow an interview. We will now discuss what an interview is. All discussions between the applicant or patent practitioner and the examiner regarding the merits of a pending application are considered an interview and are to be made of record. This includes any and all records or communications received in connection with the interview, whether the interview was conducted in person or through a telephone conversation, video conference, or in rare circumstances, electronic mail. A request for an interview may occur at any time during prosecution of an application. USPTO employees should be available to participate in interviews in order to engage stakeholders and advance prosecution. Interviews should generally be held during normal business hours, Monday through Friday, 8:30 a.m. to 5 o'clock p.m. Telephonic and video conference interviews may be held outside these hours if agreed upon by all participants. Applicants and examiners may have to adjust their work schedules in order to find a mutually agreeable time to schedule an interview. A request for an interview prior to the first office action is ordinarily granted in continuing or substitute applications. In all other applications, an interview before the first office action is encouraged where the examiner determines that such an interview would advance prosecution of the application. To advance prosecution, both the examiner and applicant should have a general understanding of the state of the art at the time of the invention. This is especially important for an interview that occurs before applicant's first reply. Once the general state of the art is determined, the examiner may suggest allowable subject matter or assist the applicant in judging the propriety of continuing the prosecution during an interview. Applicants seeking prioritized examination should be prepared to participate in an interview with the examiner. Additionally, the office has a full first action interview pilot program in which an interview is conducted before a first action on the merits. Information on this pilot program is available on the USPTO's public internet site. Applicant or examiner should schedule the interview in advance. The office has two different interview request forms depending on who initiates the interview request. If applicant initiates the request, applicant should complete the applicant-initiated interview request form PTOL 413A in addition to scheduling the interview. This is a voluntary form which also includes an agenda portion to help facilitate a focused discussion. Lack of an agenda is not a reason for the examiner to deny an interview. However, if the case is under final, an examiner may deny an interview for lack of an agenda being presented by applicant. If the examiner initiates an interview, the examiner should complete the top portion of the examiner-initiated interview summary form PTOL 413B prior to the interview. Please note that the applicant-initiated form ends with A, while the examiner-initiated interview form ends in B. For an interview with an examiner who does not have negotiation authority, arrangements should always include an examiner who does have such authority and who is familiar with the application, so that authoritative agreement may be reached at the time of the interview. Typically, this person is a trainer, supervisor, or primary examiner. Where an interview initiated by the applicant results in the allowance of the application, the applicant is advised to file a written record of the substance of the interview as soon as possible to prevent any possible delays in the issuance of a patent. Where the examiner-initiated interview directly results in the allowance of the application, the examiner may check the appropriate box on the examiner-initiated interview summary form, PTOL 413B, to indicate that the examiner will provide a written record of the substance of the interview with the notice of allowability. It should be noted, however, that the interview summary form will not be considered a complete and proper recordation of the interview unless it includes or is supplemented by the applicant or the examiner to include all of the applicable items required in MPEP 713.04 concerning the substance of the interview. More details on interview recordation will be covered later. The interview policy guidelines define a face-to-face interview as an interview where the two parties can see and interact with each other. This can be with the two parties in the same room or via video conference. The physical location of either party participating in an interview should not limit the USPTO's ability to hold face-to-face interviews. A request for a face-to-face interview will normally be granted. In some situations, a face-to-face interview is the most beneficial method of interaction between the examiner and applicant. Other times, a telephonic interview provides an appropriate level of interaction. A video conference is a meeting, usually via the Internet, using USPTO-supplied collaboration tools to visually interact and collaborate with people anywhere in real time. Video conferencing is a great alternative to applicants where an in-person interview is not available or possible. All video conferences must originate or be hosted by the USPTO. Thus, if the examiner receives a request by applicant for a video conference, the meeting invitation must be sent by the examiner and not the applicant. Verbal or written authorization from applicant must be obtained prior to sending out the video conference meeting invite. See MPEP 502.03 and 713.01 as modified by change to Internet usage policy to permit oral authorization for video conferencing tools by patent examiners 80 Federal Register 23787. As mentioned previously, GS5 to GS12 examiners should be accompanied by someone with negotiation authority, typically your trainer or SPE. Promptly notify this person of the pending interview request and obtain their availability for scheduling the interview. Once the interview is scheduled, let them know the date and time and set up a time to discuss the case with them before the interview takes place. It is recommended to ask for a detailed agenda, preferably in writing, when you contact the applicant to schedule an interview. While an agenda is not required to grant an interview, many examiners have found that requesting an agenda helps ensure a productive and focused interview. It is the responsibility of all participants to see that the interview is not extended beyond a reasonable period, usually 30 minutes. It is not unusual for a personal interview to take up to an hour for a complicated case. 1 hour of other time is typically granted for the applicant-initiated interviews on the merits, whether telephonic or in person, which includes time spent for preparing and conducting the interview. Consult your SPE before claiming any other time for an interview. The unexpected appearance of an attorney or applicant requesting an interview without any previous notice may well justify the examiner's refusal of the interview at that time, particularly in a complex case. However, the examiner should make an effort to reschedule the interview if the interview could serve to develop and clarify specific issues and lead to a mutual understanding between the examiner and the applicant, and thereby advance the prosecution of the application. An examiner's suggestion of allowable subject matter may accelerate early agreement on allowable claims. Such a suggestion should first be vetted by someone with signatory authority, preferably the trainer, primary examiner, or SPE that will later sign the case. The examiner should not hesitate to state, when appropriate, that claims presented for discussion at an interview would require further search and consideration. Nor should the examiner hesitate to conclude an interview when it appears that no common ground can be reached, or when it becomes apparent that the application requires further amendment or an additional action by the examiner. However, the examiner should attempt to identify issues and resolve differences during the interview as much as possible. All business with the Patent and Trademark Office should be transacted in writing. Examiners must complete an interview summary form, PTOL 413, for each interview where a matter of substance has been discussed during the interview by checking the appropriate boxes and filling in the appropriate blanks. As part of the recordation process, any agreement that was reached during the interview should be clearly captured on the form. An examiner can also include an attachment to the examiner-initiated interview summary form, PTOL 413B, by checking the attachment box found at the bottom of the form. An example of an attachment might be applicant's proposed agenda or a draft of a proposed claimed amendment. When importing the attachment into OAKS, the examiner can use the Office Action Appendix code in OAKS. An interview summary form is not required for examiner's amendment to put case in condition for allowance, so long as the complete written statement as to the substance of the interview is in the examiner's amendment itself. See MPEP 713.04. In a personal interview, examiners give a duplicate copy of the interview summary form along with any attachments to the applicant, attorney, or agent at the conclusion of the interview. In the case of telephonic, electronic mail, or video conference interview, examiner mails a copy to the applicant's correspondence address either with or prior to the next office communication. You may also fax a copy to applicant, attorney, or agent at the conclusion of the interview. It is desirable that the examiner orally remind the applicant of his or her obligation to record the substance of the interview in each case unless the interview was initiated by the examiner and the examiner indicated on the examiner-initiated interview summary form that the examiner will provide a written summary. It is the examiner's responsibility to see that such a record is made and to correct material inaccuracies which bear directly on any question of patentability. In order to have an effective interview, both parties should avoid unnecessary interruptions. Do not take incoming telephone calls, emails, or text messages unless it is an emergency. All parties participating in an interview should familiarize themselves with the status and existing issues in an application or re-examination proceeding before an interview. If the interview is face-to-face, the examiner should arrange his or her desk to help minimize any distractions and protect confidential information. If the face-to-face interview is via a video conference, the examiner should adjust the camera to focus on examiner. Other tips and best practices for conducting an interview can be found on the Examiner Interview Resource website found on the Patents Intranet homepage. The link to the website will be provided at the end of the presentation. The invention in question may be exhibited or demonstrated during the interview by a model or exhibit thereof. A model or exhibit will not generally be admitted as part of the record of an application. However, a model or exhibit submitted by the applicant which complies with 37 CFR 1.91 would be made part of the application record. A full description as to what was demonstrated or exhibited must be made of record in the application. See MPEP 608.03 and 713.08 for further details on how to handle a model or exhibit. Interviews may be held after the expiration of the shortened statutory period and prior to the maximum permitted statutory period of 6 months without an extension of time. Normally, one interview after final rejection is permitted in order to place the application in condition for allowance or to resolve issues prior to appeal. However, prior to the interview, the intended purpose and content of the interview should be presented briefly, preferably in writing. Such an interview may be granted if the examiner is convinced that disposal or clarification for appeal may be accomplished with only nominal further consideration. Interviews merely to restate arguments of record or to discuss new limitations which would require more than nominal reconsideration or new search should be denied. A second or further interview after a final rejection may be held if the examiner is convinced that it will expedite the issues for appeal or disposal of the application. In general, interviews are not granted to persons who lack proper authority from the applicant or attorney or agent of record, as documented in the form of a paper on file in the application. Office employees are forbidden to hold either oral or written communication with an unregistered or a suspended or excluded attorney or agent regarding an application unless it was one in which said attorney or agent is the applicant. The Office of Enrollment and Discipline, OED, is responsible for registering attorneys and agents to practice before the USPTO. Interviews are generally not granted to registered individuals to whom there is no power of attorney or authorization to act in a representative capacity. While a registered practitioner not of record may request an interview if the practitioner is authorized to do so by the applicant or the attorney of record, it is recommended that the power of attorney or authorization to act in a representative capacity be filed, preferably via EFS, web, or facsimile transmission, prior to the interview. Otherwise, the examiner must conduct the telephone interview with the office's file closed and work solely from the practitioner's file, which may be difficult to do if the interview is not in person. However, an interview with an attorney or agent not of record can be conducted if the application has not been published under 35 U.S.C. 122b and meets the requirements defined in Section 405 of the MPEP. Interviews are frequently requested by persons whose credentials are of such informal character that there is serious question as to whether such persons are entitled to any information under the provisions of 37 CFR 1.14. A mere power to inspect is not sufficient authority for granting an interview involving the merits of the application. Interviews normally should not be granted unless the requesting party has authority to bind the principal concerned. The examiner may not discuss inter partes questions ex parte with any of the interested parties. Requests for interviews on cases where a notice of allowance has been mailed should be granted only with specific approval of the TC Director upon a showing in writing of extraordinary circumstance. For attorneys remote from the Washington, D.C. area who prefer in-person or video conference interviews, the grouped interview practice is effective. Applicants should inform the office of all related cases, particularly but not limited to continuation, continuation in part, and divisional applications, and if deemed appropriate, the office should assign related cases to the same examiner to promote grouped interviewing of related applications. If in any case there is a prearranged interview with agreement to file a prompt supplemental amendment, putting the case as nearly as may be in condition for concluding action, prompt filing of the supplemental amendment gives the application special status and brings it up for immediate special action. In addition to your supervisor or trainer, you can access interview resources on the Examiner Interview Resource intranet site. Resources include setup assistance and support for video conferencing, additional interview training material, and online reference guides and material. Additional interview points of contact can also be found on the website. The Examiner Interview Resource website can be found off the Patent's homepage under Examiner Resources or at the link shown here. You should now know what an interview is, when an interview is appropriate, what to do when an interview request is made, and how to handle an interview request. You should also know when interviews are allowed and not allowed.